Let me welcome all of you to the Newark Museum and to the 19th Annual Artist Roundtable. Let me get today's first session kicked off by introducing to you the co-managing director of POBA, who has reminded me it's POBA, where the arts live. She's got quite a resume in addition to co-managing this organization with Dr. Regan McCarthy, who's also here. And so it's my great pleasure to introduce Jennifer Cohen.
Thank you, Nick, very much. We're all of us involved with POBA are thrilled to be here today and to help contribute what we can to your understanding for artists of all fields of the important steps that are required for creating and preserving one's creative legacy. And while I see that we have some artists from different fields in various stages of their careers, the outline of topics that we're going to be covering today really are important in all stages of a career, an artist's career. Let me first start by introducing you to POBA itself. POBA, Where the Arts Live, is a nonprofit initiative of the James Kirk Bernard Foundation. It was set up, it launched in 2014, in July of 2014, and it is a digital arts hub and resource center born for lovers of the arts and for exceptional artists whose legacies and collections might otherwise go undiscovered. We are dedicated to preserving the creative legacies of artists in all fields, known and unknown, amateur and professional, who may have passed away before their works were fully recognized. In addition to offering display and showcase opportunities for these artists, for their estates and families, and for the institutions that represent them, over the last year and a half, with the help of a number of our partners, we have developed what we hope you'll find is a comprehensive resource center and individualized concierge service that offers artists in all fields help with everything from archival and cataloging needs to appraising their work, to helping find ways to donate their works, editing for writers, orchestrations for musicians. And in addition to these individualized services, we post as we can various artist toolkits. Obviously, to today's agenda, we're trying to cover a number of different topics in a very short time with some very special experts. I'm sure we're only going to be touching on the basics of many of these fields, but over the next several months, we're also going to be making available on POBA not only the video excerpts from today, but also various toolkits that are supplied by our experts and by our partners in the field. The new technologies for promotion and distribution that have emerged over the last 25 years and which will continue to develop in an increasingly rapid pace really change the backdrop for career development for artists directly. New challenges arise for them. But in addition, they also impact artists indirectly, as these changes have placed many of the traditional structures of support in artist development under their own particular financial and institutional pressures, as well as marketing challenges that can disrupt and often limit the types of support that is given to artists regardless of genre or medium. My background personally is in the music industry, and while many of us celebrated the availability of the internet to make work directly available to the public, the counterthrust of that type of advance, which is mirrored in many other artistic fields, is that the industry that used to invest huge amounts of money in artist development and creative support of artists now has become increasingly impatient and incapable of doing that over a long period of time. As a result, more than ever, artists are being asked not only to make their art, but also to market and manage their careers. So we're hoping what we are doing today is giving you a bit of an introduction to the topics that you should be familiar with, even when you're working in association with the specialists, such as lawyers and publishers and gallerists, accountants and others. A basic understanding of the business of your art is really increasingly important. Today's sessions, as I mentioned, are intended simply as introductions to 3 basic topics of importance to all types of artists. And I'm very pleased that despite the rain, we have with us some leading experts in these 3 fields. The first of these 3 sessions is on an essential aspect of managing creative works. And that is basically issues relating to intellectual property rights, their protections, and as well as we're going to be looking on a very cursory level at some of the issues that are involved with licensing these rights over time and when they revert. To get us started, I'd like to introduce you to my colleague, Greg Cram, who is the Associate Director of the Copyright and Information Policy at the New York Public Library and is also a fellow survivor of the music industry.
Thanks, Jen. That's right. So I come from the library, but before that I was at Sanctuary Records, which was a large indie and certainly survived some of that turmoil. We're going to talk about copyright for the most part for the next 20 minutes or so. We're going to go through some basic copyright issues, but I also want to start off with talking about some IP issues that aren't necessarily copyright issues that you should know about as you're thinking about how to create and manage your creative works. So we'll talk about IP and copyright. Then we'll talk about licensing and selling your rights, how you can monetize those things under copyright law. And then finally, we'll talk a little briefly about legislation updates. So what's going on in DC, how might those changes impact your work as artists. But first, I've got to do my standard disclaimer because I am the lawyer in the room, I guess. So first, nothing you hear today is going to be legal advice. Everything is legal education. I am not your lawyer. If I were your lawyer, you would know because you would get a bill. Not a legal lawyer. If you have a particular situation that requires legal advice, I really strongly suggest you reach out to a lawyer to talk through that and not necessarily wait till the end of the session, or not wait to give me all of your legal questions after the program. Also, I should say nothing the presenters say today should be attributed to their organizations or their clients, and that's it with my disclaimers, I promise. Okay, so we're going to walk through some of the IP rights, basic IP rights, and then we'll get into copyright more in depth. So the first set of rights I want to talk about are patents. As artists, you're not going to have to deal with patents. All you need to remember about patents is that they are meant to protect inventors and inventions, and they do so for a certain amount of time that you don't really need to know about. But if you look, there's a patent for a toaster. That was the first pop-up toaster from 1921. So remember, patents protect inventors. Let's move on to trademarks. So POBA, where the arts live, is a trademark, and a trademark is intended to protect source identifiers. It's a word, phrase, symbol, or design that is intended to protect the identification of the source of goods or services. So think about things like Speedy Messenger Service, or Xerox, or there's an app for that, or the Nike symbol. All of those things are trademarks. So trademarks protect source identifiers. And the last right that I want to talk about before we get into copyright is the right of publicity. And it's kind of a cousin to trademark law. It's an economic right that's there to prevent people from using names, images, or likenesses of people in ways that imply some kind of sponsorship or endorsement. So it comes from state law, so different states have different laws around this, but in general, it's designed so that institutions and organizations and companies can't use a name, your name, without your permission if they're advertising or selling an item. So remember, rights of publicity protects identities. Okay, so let's get into the real reason why I'm here, which is copyright. So raise your hand if you created a work protected by copyright today. How many of you created a work protected by copyright today? All right, so did you write a Facebook post, shoot a Vine video, write an email, draw a doodle, take a photograph, write a paper? If you did any of those things, you should raise your hand because you created something protected by copyright law. Copyright is everywhere. It protects a lot of things that you don't necessarily think about. So all of you should have raised your hand when you said, did you create something protected by copyright law? So why should you care about copyright law, despite the fact that it is everywhere? Well, the maximum statutory damages for copyright infringement are as high as $150,000 per work infringed. $150,000 per work infringed. So depending on which side of the case you're on, that's either a really good thing because that's a big time statutory damage, or it's a really bad thing because you were on the wrong side of that lawsuit. Unfortunately, the costs of litigation around copyright issues are increasing. Today, we're at a minimum of about $380,000 per side to litigate a copyright lawsuit. Those legal fees can get up to as high as $2 million. So copyright litigation is expensive. So I'm kind of here to help expose you to some basics of copyright law to help you kind of avoid these costly lawsuits. But remember, talk to your legal advisor if you have specific questions. Okay, so where does copyright come from? It comes from the Constitution. It's based in the Constitution. Article 1, Section 8, Clause 8 says that Congress shall have the right to pass laws to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Congress has taken up the Constitution's invitation to create copyright law and has done so since 1790. And so why has Congress invested so much time and effort into copyright? Well, there's two theories. One theory is that the authors and creators will not create new works if their rights aren't protected, if there's no incentive for them to do so. Remember, every copy competes against itself in some ways, so we're worried about unlimited copies out there destroying the market for those works. Therefore, we give rights holders certain exclusive rights to make copies and control the number of copies that are out there so that there is an incentive to create new works. On the other side, there's another theory about copyright law that says that part of the reason why we have copyright law is to enhance the public education of the country. In fact, the first copyright law ever created was called an Act for the Encouragement of Learning. The idea there is to incentivize new creation of new works so that we can create new knowledge and new insights and build off of others' works. That's why we have this limited times in the Constitution. All right, so what does copyright protect? Well, it's actually easier to answer what does copyright not protect, because copyright protects so much. So things that aren't protected by copyright law are things like ideas, procedures, processes, systems, methods of operation, concepts, principles or discoveries, all of those things not protected by copyright law. Instead, copyright law protects original works of authorship fixed in a tangible medium of expression. You're going to hear me say this phrase a couple of times. So original works of authorship fixed in a tangible medium of expression. What do I mean by original works? Well, let's start with original. What does it mean to be original? In the art community, it's always interesting to ask that question because everything is so referential or can be referential. But really what it means for copyright parlance is that it has to have a modicum of creativity. It has to have some basic creative effort or a value there, a modicum of creativity. Think about things like white pages of phone books, right? No copyright protection there. Those are all facts, so not even a modicum of copyright protection for those kinds of things. So I said a modicum of creativity, so it's got to be an original work of authorship fixed in a tangible medium of expression. By fixation, I mean things like what you would imagine. So chiseling into stone, form of fixation. Writing things down, form of fixation. Courts have even told us that things that are stored in computers, that are created in computers and stored there, are in fact fixations, even though they're just electrons. So ultimately, copyright protects things like books, fine art, music, movies, but ultimately format doesn't matter here. All that matters is that it is a creative work fixed in a tangible medium of expression. Okay, so you're a rights holder, so what do you get as a rights holder here? Well, you get a set of exclusive monopoly rights. We call that, in the trade, we call that a bundle of rights. It's the right to do something or to prevent others from doing something. So the basic rights that you get as a rights holder is the right to reproduce something, the right to copy it. That's your first right. Your second right is to create derivatives. So think about the Hunger Games. It was a book first, and then it was a movie. That movie is a derivative of the book, and therefore the movie had to seek permission from the book, the author, the rights holder of the books, to create those movies. The third right that you get as a rights holder is the right to distribute your work. Think about passing out copies of your works. That's what we mean by distribution. And finally, the last set of rights that you get are the right to publicly display and perform your work. So I work at the New York Public Library main branch at 42nd and 5th Ave in Manhattan. Every summer out back of the library, there's a film festival every couple of weeks. HBO essentially plays a free film on the screen, and hundreds, if not thousands, of people come and sit on the lawn. That is a form of public performance, and HBO, or the sponsors, Bryant Park in particular, have to license that public performance from the rights holders. So remember, the rights that you get are you get the right to make copies, to make derivative works, to distribute your copies, and to publicly perform and display those works. For visual artists in the room, you get a little bit extra. There was a law passed in 1990 called the Visual Artists' Rights Act, also called VARA. You'll hear it referred to VARA throughout the rest of the program. The US chose to protect certain aspects of moral rights. Moral rights are something not necessarily economic rights, but they're something else. And the two moral rights the US chose to protect were the right of attribution and the right to the integrity of your work. So VARA, although it's got some lofty claims, what we really only are protecting by these extra rights are things that are paintings, drawings, prints, exhibition photos, sculptures, and they've got to be limited to less than 200 copies. They've all got to be signed, and they've all got to be numbered. If you are in one of those situations, you have certain VARA rights. And those rights, there's four main kind of rights that you get with VARA. You get the right to claim authorship of your work. You get to make sure that your name is associated with your work and tell everyone that you did. Second, you have the right to prevent the use of your name on any work not created by you, especially that you didn't create. The third right is the right to prevent the use of your name on any work that has been distorted, mutilated, or modified in ways that would bring your reputation down, that would hurt your reputation. And the fourth VARA kind of right that you get is the right to prevent distortion, mutilation, or modification of your work in a way that would hurt your reputation. All of these rights, these VARA rights, can be waived, but only in writing. So if you are doing a public installation of a work, you will likely be asked to sign away some of these rights. If not, you may have VARA rights. So all of these rights that I just went to are subject to exceptions and limitations. For example, although a rights holder has the exclusive right to distribute copies of their works, once they've distributed a particular copy, that copy can be resold by someone else without permission of the rights holder. That's called the first sale doctrine for us, and that's why we have things like secondary markets, why we have used record stores, or eBay, or Goodwill even, or even libraries. We rely on the first sale exception and limitation to copyright law to allow us to lend books. The other exception that we should mention, but we're not going to have time to get into, we can get into it in questions if you have questions about it, is fair use. Fair use is an exception and limitation to the law that plays a critical role in balancing the rights of rights holders with that of free speech. It's a critically important exception that allows users to use works in certain ways without seeking permission of the rights holder. Okay, let's talk about copyright ownership for a second. So MoMA has a lot of very nice paintings hanging in their walls. One of them is a Vincent van Gogh. And the question is, does MoMA own the copyright in that Van Gogh painting? And the answer is no. Just because you own the physical item doesn't mean you own the copyright in the item. Right now, I could draw a scribble, a doodle on a piece of paper, throw it away. You might retrieve it from the trash because I'm such a great artist. And in 50 years, if you reproduce that work, guess what? I have a copyright, or maybe my heirs have a copyright in that and can come after you for your use of my work if you're not using it in ways consistent with exceptions and limitations. Another example is think about a letter author, someone who writes a letter. I know we don't do that very often anymore by handwriting letters, but even emails. If you sent that letter to someone else, you still own the rights, that copyright in that letter. The person who received the letter doesn't actually own rights in that, even though you may not actually have a copy of that letter yourself. Okay, I want to talk about duration. So copyright today lasts life of the author plus 70 years, but that's changed over time. Our first copyright law was actually 14 years. You got a copyright in your work for 14 years and had to renew it for another 14. But today, we have automatic copyright protection. Under US law, anything that is within the scope of the protection of copyright law is granted copyright protection at the moment of creation. You no longer have to register your work in order to get copyright protection. However, registration does confer certain benefits, which we'll talk about right now. Registration is actually pretty straightforward. You can do it online. It costs $35 for a single application, $55 for most of the rest of registrations. If you do it on paper, it's going to cost you even more. It's going to cost $85 per work. But go to copyright.gov and do it that way. If you do register, you get some benefits. First, you have evidence of ownership. You get to show the world that you are the rights holder in that thing, in that work that you created, and therefore you have a documented proof that you are the owner of that. Second, you are required to register your works if you want to litigate any kind of copyright claims. So you need to register if you want to litigate. And third, registration also allows you to record that registration with the US Customs Service in case you are worried about importation of fakes. You are allowed to file that registration with the Customs Service and prevent the importation of works that are infringements of yours. Well, the last part of the copyright section here, I want to talk about infringement. Because I said at the beginning, $150,000 per work infringed is the maximum statutory damages. That's only the case if the rights holder has registered their work within a certain amount of time and has hit the maximum, which is willful infringement. Generally, though, the two kinds of remedies that you get under copyright law are lost earnings on the infringement of your work, and if you've registered it, you will get statutory damages. You can ask for statutory damages, which in the most cases is up to $30,000 per work infringed. The second remedy that you get is you can ask a judge to order the infringer to stop doing whatever they're doing. Okay, that's it for the copyright section. Now I want to talk about creating, selling, and licensing of your works. As I said, the rights holder owns many of these rights initially, but all of the rights that I just talked about can be licensed to others or assigned to others for their own use. These things can be licensed exclusively or non-exclusively. You can do it for any length of time that you like. And although licensing in each creative industry is slightly different and has its own kind of customs, there are a few common terms that you find in many of these agreements. I'll walk through a few of those now. So the first one is, how is the work being used? If someone wants to license your work and use it in a particular way, you want to make sure that you've documented in your license how they're actually going to use your work. You also want to know for how long is that person going to use your rights or a particular right. You also want to know how much. How much are you getting paid for this? What is the tit for tat on this? And finally, I guess not finally, in what territory are we talking about licensing this? Are we talking about just the US? Are we talking about just New York? Can I only make reproductions of this in New York State, or can I only do it in France? Where can I make reproductions of this or make use of your rights? And finally, what happens if something goes wrong? You want some kind of protection in your contract about what happens if something goes wrong in one of these agreements. How do you end these kinds of agreements? All right, last, I guess there's one more section of the copyright law, which is termination. So copyright law also recognizes the value of a work is not always known at the time of creation or at the time when the person needs to license their work. So if you are a starving artist and you need that $500 licensing check now, otherwise you're not going to be able to eat next week, but in 50 years or 30 years, all of a sudden your work is really, really valuable, and that $500 deal you did a long time ago seems kind of unfair to you. Copyright law has a provision in it that allows you to terminate those kinds of agreements. Copyright law gives authors and artists the ability to terminate assignments and licenses after a certain amount of time. There's lots of rules around termination, but generally you need to start the process 35 years after your assignment, after the grant of rights. I should also note it doesn't really apply to works made for hire, although I suspect most of you are not on works made for hire.
You were talking about the reversion clause in the 1976 Copyright Act that enables artists who haven't, in all fields, who haven't done their work as works for hire to recapture their rights and renegotiate their deals after 35 years. I think there's a particular window of time during which this can happen.
Yeah, that's right. So I make sure you talk with an attorney or really look in this if you're going to take on reversion, because it can be something a little complicated. But in most cases, you have at year 35 of your grant of license, you have a 5-year window to send a certain number of letters and to say certain things to reclaim your rights. So there is a limited window here. Many in the music industry are taking advantage of this, arguing that they weren't under works for hire, where actually it's an employer who owns the rights in your work as an author. They are the rights holder in it. But for works not made for hire, for other works, there is this possibility of reversion.
Right. Another thing is, while we understand copyrights exist for all forms of audio and visual creation, they don't necessarily exist by themselves. That often you find in the different arts layers of copyrights that coexist. So what comes to mind is in the case of a photographer, you have the rights of publicity as well as the rights to the actual photograph itself and the ownership of the photo. In the case of music, there's the copyright in the sound recording as well as the copyright in the actual musical composition. So I was hoping you could talk about how people have to be aware of the different levels of rights.
So my organization collects a lot of material. NYPL collects a lot of different kinds of material, and one of our charges is to make that material available online as much as we can. When we're talking about audio moving image material, then we're talking about very complex things. There are can be many rights holders in the stack, in the individual work itself. You may be looking at a simple photograph of a sculpture, for example, a 3-dimensional sculpture. The people who own rights in that could likely include the photographer and the sculpture, the person who created the sculpture underlying it. That means I need to clear both the sculpture and the photograph if I want to use that particular photograph in some way that's beyond an exception limitation. Yeah, it can get complicated, but you need to just look at the whole item as itself and try to analyze how many different kind of rights there are in that item.
There were 2 other areas. You touched briefly on derivative works. And sometimes derivative works are done by the same author, and sometimes derivative works come from other authors, and sometimes they come from material that's in the public domain, where as an arranger, you can still get a copyright. Can you talk about that a bit?
So I'll do another plug for NYPL. So we just released 180,000 images in high resolution that we've determined to have no known U.S. copyright restrictions. Anyone can take those images and remix them and use them in different ways. Those people who remix those things own a right in their derivative work and didn't need to seek our permission because those items are in the public domain. Now, had a person gone and taken a photo that they found online, for example, and wanted to reuse or remix that, they would need to talk to the rights holder unless they're using it in a way that's consistent with an exception and limitation. If they were using it just a straight remix and they were not claiming fair use or anything, then they would need to seek talk to the rights holder of the original work to clear that, and then they would likely own a copyright in their derivative, their creative energy that went into changing that item.
And the one last thing that I find particularly important, and I think is particularly important for artists in all fields, is how to segregate their rights and define their rights as specifically as possible for their licensing agreements. In the music industry, obviously technologies have changed so vastly that what was a good deal for vinyl is not necessarily a good deal for CDs or MPEG-3s. And so the question is, in addition to all the other parameters that artists should be aware of, how can they best define the individual rights that they're granting?
Be specific as you can. In those license agreements, you need to be specific. And the other thing to do is to keep copies of all of those assignments and licenses. I can't tell you the number of people that come talk to me and tell me about this bad deal that they're in, and they really want to get out of it, and they really want to fix it. And I say, where's the license? What's the license say? And they say, I don't have a copy of it. Keep copies. In fact, it's helpful even if you inventory those copies, right? Have a list of all of the rights that you have licensed or assigned, so that you know which rights you have left, or which ones you have granted non-exclusive licenses to, so that you know how to approach future licensing deals.